Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only and does not constitute professional legal, financial, or psychological advice. The topics discussed, including divorce proceedings, asset division, and social mobility trends, are complex and subject to varying state laws and individual circumstances. Viewers are strongly encouraged to conduct their own due diligence and consult with qualified professionals, such as attorneys or financial advisors, before making any decisions related to their personal or legal affairs. In the next 60 seconds, approximately 4 men in the United States will enter a legal process that, according to historical trends, may reduce their individual net worth by nearly 41% almost overnight. For many, this is not just the end of a marriage. It is a fundamental collapse of their trajectory on the American social mobility ladder. We often talk about the glass ceiling in the workplace or the hurdles of the educational system, but we rarely discuss the most efficient wealth destruction engine for the American male: a high-conflict, unmanaged divorce. This is the silent killer of the middle class. It is the moment where a decade of career growth, disciplined saving, and strategic investment can be liquidated in a matter of months to cover legal retainers and the sudden, jarring requirement of funding two separate households on the same pool of capital. If you are watching this, you might feel like you are standing on the edge of a financial and social abyss. You are likely wondering if the life you have built is about to be systematically dismantled, and more importantly, if you will ever be able to climb back up to the station you currently occupy. The problem we are solving today is the preservation of your future. We are going to look past the emotional wreckage and analyze divorce through the lens of socioeconomic survival and long-term upward mobility. This deep dive is designed to provide you with the historical context, the data-driven reality of the U.S. legal system, and the strategic framework necessary to navigate this transition without becoming a statistical casualty of downward mobility. We are looking at how to protect the foundation of your productivity, your creditworthiness, and your ability to remain an active participant in the economy of the future. To understand why divorce is such a pivotal moment for social mobility, we must first look at the historical trends of the dual-income household in the United States. Since the late 20th century, the American dream has increasingly relied on the two-income trap, a concept where middle-class status is predicated on the combined earning power of two adults. When this unit dissolves, the economic efficiency of the household does not just split in half, it often shatters. Historical data suggests that while women often experience a sharper decline in immediate household income, men frequently face a more persistent, long-term struggle with lifestyle erosion due to the high cost of maintaining a separate residence that is suitable for shared parenting, coupled with the ongoing transfer of wealth through alimony and child support. These are not just monthly expenses. They are capital outflows that prevent the accumulation of compound interest, which is the primary vehicle for moving from the middle class to the upper middle class. Consider the case study of a mid-career professional in a high-cost-of-living area like Northern Virginia or Southern California. This individual may be earning a six-figure salary, which on paper places them in the top quintile of earners. However, social mobility is not defined by income alone. It is defined by the delta between income and expenses, and the ability to convert that delta into appreciating assets. Upon the filing of a divorce, this professional is suddenly faced with the two-household trap. They must now secure a second lease or mortgage in a market where interest rates and property values remain at historic highs. They are no longer splitting a $3,000 mortgage. They are paying that mortgage plus an additional $2,500 in rent. This $30,000 annual increase in housing costs is a direct hit to their ability to invest in their 401k or brokerage accounts. Over a 10-year period, assuming a conservative 7% market return, that divorce tax on housing alone represents a potential loss of nearly $415,000 in retirement wealth. This is how the trajectory of social mobility is permanently altered. Furthermore, we must address the legal friction factor. In the United States, the average contested divorce can cost anywhere from $15,000 to over $100,000 in legal fees per person. These are liquid assets, often pulled from emergency funds or high-yield savings accounts, that vanish into the service economy. For a man attempting to maintain his social standing, this loss of liquidity can be catastrophic. It reduces his risk capacity, the ability to take professional risks, such as starting a business or switching to a higher-stakes career path, because he no longer has the financial cushion to sustain a period of low income. When you lose your liquidity, you lose your mobility. You become tethered to your current salary out of sheer necessity to meet court-ordered obligations, effectively stalling your career growth at a time when you should be hitting your peak earning years. The impact on creditworthiness is another often overlooked variable in the social mobility equation. During the dissolution of a marriage, joint debts, mortgages, car loans, and credit cards frequently become points of contention. Historical trends show that even in cases where a court orders one spouse to pay a debt, the creditor still holds both parties liable. One missed payment by a disgruntled or overwhelmed former partner can tank a man's credit score from the 800s to the low 600s in a single billing cycle. In the modern U.S. economy, your credit score is your passport to social mobility. It dictates your insurance premiums, your ability to secure business loans, and even your attractiveness to potential employers in certain sectors. A divorce that results in credit damage is a divorce that locks a man out of the financial tools required to rebuild. We also need to discuss the human capital aspect of social mobility. Professional success is rarely a solo endeavor. It is the result of a stable home base that allows for maximum focus and energy in the marketplace. When a man enters the divorce fog, a period of high cortisol, sleep deprivation, and psychological strain, his workplace performance often suffers. This can lead to missed promotions, lower performance bonuses, or in extreme cases, job loss. In a competitive U.S. labor market, a one-year dip in productivity can have a compounding negative effect on a career trajectory that lasts for a decade. This deep dive will analyze how to treat your career as your primary asset during this period, ensuring that the legal process does not consume the very engine that generates your wealth. We will also explore the specific challenges of the Qualified Domestic Relations Order, or QDRO. For many American men, their largest asset outside of home equity is their retirement account. The division of a 401k or pension plan is not just a 50% haircut. It is a disruption of the most powerful wealth-building tool in history, time. When a 45-year-old man loses half of his retirement savings, he is not just losing the cash value. He is losing the 20 years of compounding that those dollars would have generated. To achieve the same level of retirement security, he would have to contribute significantly more than his peers who remained married or who managed their divorce with a focus on asset preservation. This is the wealth gap that nobody warns you about. It is the difference between a retirement of leisure and a retirement of continued labor. By the end of this masterclass, you will understand the structural forces at play in the American legal and economic systems that tend to pull men downward during a divorce. We will move beyond the common tropes and look at the actual levers you can pull to stabilize your situation. We will discuss the potential outcomes of mediation versus litigation, the importance of financial forensic awareness, and how to reframe your post-divorce life not as a period of scarcity, but as a strategic pivot toward a more sustainable and independent form of social mobility. The goal is to ensure that when the dust settles, you are not just surviving, but you are positioned to thrive in an economy that demands resilience and financial agility. This is about more than just getting through a legal process. It is about protecting the legacy you have worked so hard to build. To navigate the storm of social downward mobility, we first have to dissect the anatomical structure of what financial advisors call the divorce penalty. For the American man in 2026, this is not just a legal disagreement, it is a forced liquidation event. Imagine a scenario involving a professional named David. David is 44 years old, living in a suburb of Charlotte, North Carolina. He has spent the last 15 years climbing the corporate ladder in fintech. By early 2026, David and his spouse have built what looks like a fortress of stability. A $750,000 home with a grandfathered 3% mortgage rate, $200,000 in combined 401k accounts, and $50,000 in a liquid high-yield savings account intended for their children's college fund. In the eyes of the U.S. Census Bureau, David is firmly in the upper middle class. He represents the peak of social mobility for his family line. However, the moment the petition for dissolution is filed, the math of his life changes from addition to a very aggressive form of subtraction. The first historical trend we see in these cases is the liquidity crunch. In the U.S. legal system, assets are often categorized as marital or separate. Since David earned his wealth during the marriage, almost everything is on the table for an equitable distribution. But here is where the social mobility ladder begins to shake. To stay in his home or buy out his spouse, David faces a 2026 reality where mortgage rates have shifted significantly from that 3% floor. If he has to refinance the house to pay out his spouse's 50% equity share, his monthly housing obligation could realistically jump from $2,400 to over $5,000 overnight. This is the first step toward downward mobility. That extra $2,600 a month is not just money gone. It is the death of his investment capacity. It is money that previously went into the S&P 500 or his children's 529 plans, which are the primary engines for staying in the upper class across generations. When we look at the step-by-step breakdown of asset division, we must account for the tax consequences that often blindside men. If David decides to liquidate a portion of his brokerage account to pay for his legal retainer, which in a contested 2026 case can easily exceed $30,000 in the first 6 months, he is not just losing the $30,000. He is triggering capital gains taxes. Depending on his income bracket, he might be losing 15 to 20% of that withdrawal to the IRS. This is a double hit to his net worth. Historical trends suggest that men often prioritize keeping the house for the sake of the children, while the spouse takes the more liquid retirement accounts. This is a strategic error for someone concerned with social mobility. A house is a liability that requires maintenance, taxes, and insurance. A 401k is a compounding asset. By choosing the house, many men trap themselves in a high-expense, low-growth environment that effectively anchors them to their current income level with no room for error. Let us look deeper into the concept of the professional zip code. In many U.S. metros, your physical location is a proxy for your professional network. Social mobility is often a game of proximity. Imagine if David has to move from his stable, high-status neighborhood into a smaller one-bedroom apartment in a lower-cost area to manage his new cash flow reality. This shift does more than change his commute. It impacts his social capital. He is no longer attending the same neighborhood functions, he is no longer bumping into the same caliber of professional peers at the local gym, and his psychological state shifts from one of abundance to one of survival. Data indicates that men who experience a sharp decline in their living standards during a divorce are more likely to experience a corresponding drop in professional confidence. They stop taking the calculated risks that lead to promotions. They stop investing in their own continuing education. They enter a state of defensive living. In the 2026 economy, the cost of expert witnesses adds another layer of complexity. If David owns even a small side business or has stock options that have not yet vested, the legal process will likely require a business valuation expert. These professionals often charge between $5,000 and $15,000 just for a single report. When you combine this with the hourly rates of family law attorneys in major U.S. hubs, which now range from $400 to $700 per hour, you see how a man's liquid safety net can be incinerated in a single fiscal quarter. This is why we call it a deep dive masterclass. You have to see the hidden plumbing of the system. The system is designed to reach an equitable outcome, but the friction costs of reaching that outcome are borne almost entirely by the marital estate, often leaving both parties significantly lower on the socio-economic scale than when they started. To counter this, a man must perform a ruthless financial audit in the first 30 days. Step 1 is the identification of separate property. Did David receive an inheritance? Did he have a brokerage account before the wedding that was never commingled? In many jurisdictions, these are the lifeboats. If he fails to document these meticulously, they will be sucked into the marital pot and split. Step 2 is the valuation of debt. In 2026, with consumer credit at record highs, many couples are splitting more debt than assets. If David is assigned the credit card debt in exchange for a larger share of a depressed asset, he is effectively taking on a high-interest anchor that will prevent him from regaining his footing for years. Step 3 involves a projection of his post-divorce tax filing status. Moving from married filing jointly to single or head of household can result in a significant increase in tax liability, further reducing the discretionary income he needs to rebuild his life. Consider the case study of a senior engineer in Austin, Texas. We will call him Michael. In 2026, Michael went through a high-conflict divorce. He assumed that because he made a high salary he would be fine. He didn't account for the fact that his bonus structure was considered marital property, or that his spouse's attorney would file motions that required him to produce 10 years of financial records, each hour of which his own attorney billed at $500. Michael's mistake was not the divorce itself. It was the failure to recognize that his divorce was a corporate merger in reverse. He treated it like an emotional event, while the court treated it like a balance sheet adjustment. By the time the final decree was signed, Michael had lost 40% of his retirement, 60% of his liquid cash, and was living in a rental unit that cost him 40% of his take-home pay. His path to social mobility was not just paused, it was reset by 15 years. This is the reality we are addressing. It is not about bitterness. It is about the cold, hard data of how wealth is transferred and destroyed in the American legal system. You have to be the CEO of your own divorce. You have to understand that every emotional outburst in a courtroom has a dollar value attached to it in the form of billable hours. You have to realize that the U.S. social mobility dream is fragile and requires constant nourishment through compound interest and low debt. Divorce, if unmanaged, is the antithesis of that dream. As we prepare to move further into this deep dive, we have to look at the one factor that can either save your future or bury it: the calculation of long-term support and the hidden traps within child support formulas that do not account for the actual cost of living in 2026. In the next part, we are going to look at the career sabotage phase. There are specific ways the legal process can accidentally or intentionally freeze your professional licenses, impact your security clearance, and even prevent you from taking that high-paying international assignment that was supposed to be your ticket to the next level of wealth. Do you know how a simple temporary order can legally bar you from moving for a better job? We are going to break down the mobility laws that every ambitious man needs to know before he signs a single document. The moment a divorce petition is filed in most United States jurisdictions, an invisible cage descends around your professional life. This is often executed through what is known as an automatic temporary restraining order, or ATRO. While the name sounds like it is designed to prevent domestic conflict, in the realm of social mobility, it serves as a financial and geographic freeze. For an ambitious man in 2026, where the economy favors those who can move rapidly to where the capital and opportunity are, an ATRO is a significant hurdle. It typically prevents the transfer, encumbrance, or concealment of any property, but its reach often extends to your very ability to advance your career. Imagine a professional named Marcus living in Northern Virginia. Marcus is a senior systems architect for a federal contractor. In early 2026, he is offered a vice president position at a burgeoning tech firm in Austin, Texas. This role comes with a 40% salary increase and a substantial equity package that could catapult Marcus into the top 1% of earners over the next decade. However, Marcus is 4 months into a contested divorce. Because his current custody arrangement is based on his residence in Virginia, and the ATROs prevent him from making major changes to the children's environment or his own financial footprint without court approval or spousal consent, Marcus is stuck. Historically, cases show that if the spouse does not agree to the move, Marcus must file a motion for a temporary order to relocate. In a backlog 2026 court system, that hearing might not happen for 6 to 9 months. By then, the job in Austin is gone. This is how the legal process creates a ceiling on your social mobility, tethering you to a lower earning geography while your peers continue to climb. We must also analyze the precarious intersection of family law and professional licensure. In the United States, almost every state has laws that allow for the suspension of professional licenses if a person falls behind on child support or alimony. This includes medical licenses, law licenses, engineering certifications, and even commercial driver's licenses. Historical trends indicate that these suspensions are often automated within state systems. If Marcus experiences a temporary cash flow crunch because he is paying for 2 households and high legal fees, and he misses a single payment, the system doesn't care about his intent. A suspended license in 2026 is a career-ending event for many high-earning professionals. The irony is systemic. The state removes your ability to earn the very money it is demanding you pay. This creates a downward spiral where a man loses his station in society, not because of a lack of skill, but because of a procedural trap. To avoid this, a man must prioritize the support obligation as a non-negotiable business expense, treating it with the same existential weight as a tax lien. Then there is the issue of security clearances, which are a cornerstone of social mobility for men in the defense, aerospace, and cybersecurity sectors. In 2026, the federal government's continuous evaluation system monitors the financial health of cleared individuals in real time. Under Guideline F of the Adjudicative Desk Reference, financial considerations are the #1 reason clearances are revoked or denied. The logic used by the government is that a person under extreme financial distress is a target for coercion or may engage in illegal activity to solve their debts. If your divorce involves high levels of consumer debt, or if your spouse's attorney makes aggressive claims about your financial stability, it can trigger a flag on your SF-86. A man who loses his top-secret clearance doesn't just lose a job. He loses his access to an entire tier of the American economy. He is effectively demoted from a high-value specialist to a generalist, often resulting in a 50% drop in career-long earning potential. Let us look at a step-by-step breakdown of the imputed income trap. This is a legal doctrine where a court decides you should be earning more than you currently are, and they base your support obligations on that theoretical number rather than your actual paycheck. Imagine if Michael, who we discussed earlier, decides to leave his high-stress corporate job to start a consultancy in 2026, hoping to build long-term wealth. If his spouse can prove that Michael has the capacity to earn his previous high salary, the court may find him voluntarily impoverished. The court then imputes his old salary. Michael is now trying to build a new business while being court-ordered to pay support based on a salary he no longer receives. This is a common historical outcome that leads to the total bankruptcy of many male-led startups during a divorce. To navigate this, any career change must be documented as a good faith move, often requiring expert testimony to prove that the new path is more sustainable or has a higher long-term ceiling for the marital estate's benefit. The geographic restriction trap is another subtle but devastating blow to mobility. Most standard custody orders include a radius clause, often 50 or 100 miles. This means that for the next 10 to 15 years, or until your youngest child reaches 18, you are legally barred from moving outside that circle without a judge's permission. In an era where the U.S. labor market is increasingly centralized in specific superstar cities, being locked into a secondary or tertiary market can stunt your professional growth. If the industry you work in moves to a different state, you are left behind. You cannot follow the talent, the capital, or the innovation. This turns your career into a localized asset, which is far more vulnerable to regional economic downturns. Historically, men who are geographically restricted see their wage growth slow by nearly 30% compared to their mobile counterparts over a 10-year period. Furthermore, we must address discovery abuse as a tool for career sabotage. In a high-conflict 2026 divorce, a spouse's attorney may issue subpoenas to your employer, your HR department, and your business partners. They may demand every email, every expense report, and every performance review you have had in the last 5 years. While this is legally permitted under the guise of finding hidden assets, the practical effect is the destruction of your professional reputation. Your employer now sees you as a liability and a distraction. You are no longer the focused, high-performing asset they want to promote. You are the guy whose personal life is leaking into the boardroom. This reputational friction is a silent killer of social mobility. It doesn't show up on a balance sheet, but it manifests in the promotions you don't get and the projects you aren't assigned. To protect your career, you must treat your professional identity as a separate entity from the marriage. Step 1 is the professional firewall. You must notify your attorney immediately if any legal maneuvers threaten your license or clearance. Step 2 is strategic transparency with your employer. It is often better to provide a high-level, professional heads-up to HR rather than letting them be blindsided by a subpoena. Step 3 is the mobility carve-out. When negotiating your final decree, you must fight for language that allows for geographic flexibility for career advancement, even if it means adjusting the visitation schedule or paying for the children's travel costs. If you don't bake mobility into your divorce decree, the law will bake stagnation into your life. As we conclude this segment on career preservation, we have only scratched the surface of the institutional forces that can derail your progress. While your career is the engine of your mobility, the IRS is the navigator that can either guide you to safety or lead you into a tax trap that lasts for decades. In the next part, we are going to look at the IRS shadow spouse. We will break down why your filing status in the year of your divorce could result in a tax bill that wipes out your remaining liquid savings, and how the 2026 tax brackets are specifically designed to penalize the newly single high earner. Do you know the difference between a tax-advantaged asset transfer and a taxable event during a property split? If you get this wrong, you might end up paying your spouse's taxes for the next 5 years. We are going to dive into the math that your divorce attorney likely isn't telling you. The tax code is the silent partner in every divorce, and in 2026, that partner has become significantly more aggressive. To understand the impact on your social mobility, you have to look at the December 31st rule. In the eyes of the Internal Revenue Service, your marital status for the entire calendar year is determined by your status on the final stroke of midnight on December 31st. If your divorce decree is signed on the final day of the year, the IRS views you as single for all 365 days of that year. This is not a mere clerical change. It is a fundamental shift in your tax liability that can result in a 5-figure surprise when you file in April. Let us analyze a case study involving a project manager named Robert, based in Denver, Colorado. In early 2026, Robert earns $225,000 annually. While married filing jointly, Robert and his spouse benefited from a larger standard deduction and wider tax brackets. However, as 2026 begins, we are seeing the historical fallout of the sunsetting provisions of the 2017 Tax Cuts and Jobs Act. For Robert, moving from a joint filer to a single filer in 2026 means his top marginal tax rate could jump significantly. Imagine if Robert's effective tax rate increases by just 5% due to the loss of joint brackets and the reduction of the standard deduction. On a $225,000 income, that is an additional $11,250 in taxes that he previously used for mortgage payments or retirement contributions. For a man trying to maintain his social standing, this is an immediate erosion of his discretionary income, effectively capping his ability to reinvest in himself or his business ventures. Then there is the basis trap, which is perhaps the most sophisticated way wealth is inadvertently transferred during a divorce. When assets are divided, many men look only at the current market value. If Robert is offered $100,000 in a checking account and his spouse takes $100,000 in a brokerage account containing tech stocks, Robert might think this is a fair 50-50 split. However, this ignores the concept of cost basis. If those tech stocks were purchased years ago for $20,000, they have an $80,000 embedded capital gain. When the spouse eventually sells those stocks, she will owe capital gains tax on that $80,000. If Robert takes the cash, he gets the full $100,000 tax-free. Conversely, if Robert is the one who takes the highly appreciated brokerage account, he is actually receiving significantly less than $100,000 in spending power because he has inherited a future tax bill. Historical trends show that men who do not perform a tax-adjusted valuation of assets often end up with a net worth that is 10 to 15% lower than it appears on the final divorce decree. We must also dive into the real estate tax hammer. In the United States, a married couple filing jointly can exclude up to $500,000 of gain from the sale of their primary residence from their taxable income. Once you are single, that exclusion drops to $250,000. Imagine if Robert and his spouse own a home in a high-growth area like Denver that has appreciated by $450,000 since they bought it. If they sell while married, they pay zero tax on that gain. If Robert buys out his spouse, keeps the house, and sells it 2 years later as a single man, he will owe capital gains tax on the $200,000 that exceeds his individual exclusion. At a 20% long-term capital gains rate, plus potential state taxes, Robert is looking at a $40,000 plus tax bill that he wouldn't have faced had the timing or structure of the split been different. This is money that could have been used to fund a new business or a child's education, directly impacting his family's multi-generational social mobility. The 2026 landscape for alimony, or spousal support, adds another layer of complexity. Under the tax laws that took effect in 2019 and remain the standard in 2026, alimony payments are no longer deductible for the payer and are not considered taxable income for the recipient. This was a massive shift from decades of historical precedent. For Robert, this means if he is ordered to pay $4,000 a month in alimony, he is paying that with post-tax dollars. He has to earn roughly $6,000 to have $4,000 left to give his former spouse. The recipient, however, gets the full $4,000 without owing a cent to the IRS. This creates a situation where the man's effective cost of support is much higher than the face value of the check, while his ability to save for his own future is drastically curtailed. This is a structural barrier to upward mobility, as it significantly increases the burn rate of a man's income. Furthermore, we must address the Qualified Domestic Relations Order, or QDRO, which is the legal mechanism used to split 401k and pension plans. While a QDRO allows for the transfer of funds between spouses without triggering the 10% early withdrawal penalty, it does not exempt the funds from being taxed as ordinary income if they are liquidated. Often, in a 2026 divorce, a man might be tempted to pull cash out of his 401k via a QDRO to pay off a mortgage or a legal debt. This is a high-stakes move. If Robert pulls $50,000 from his 401k during the divorce, that $50,000 is added to his $225,000 income, potentially pushing him into an even higher tax bracket. He could end up losing nearly 40% of that withdrawal to federal and state taxes. Step by step, he is dismantling his long-term wealth to solve a short-term liquidity crisis, which is a classic precursor to downward social mobility. To mitigate these potential outcomes, a professional approach requires a deep dive into the 2026 tax brackets before any settlement is signed. Step 1 is a pro forma tax return. A mock filing that shows exactly what your taxes will look like as a single man compared to your current status. Step 2 is a basis audit, where every investment asset is assigned its original purchase price to calculate the hidden tax liability. Step 3 is the negotiation of the dependency exemptions and child tax credits. While these were limited by the TCJA, their 2026 status is a key negotiating point. Who gets to claim the children can mean a difference of thousands of dollars in annual tax savings, which, when compounded over the remaining years of a child's minority, represents a significant pool of capital for rebuilding a man's estate. As we move forward, it becomes clear that the financial hit of divorce is not just about what you lose today, but about the friction it creates in your ability to grow tomorrow. But money and taxes are only half the battle. The other half is the social architecture of your life. In the next part, we are going to look at the social capital collapse. We will analyze how the loss of a joint social circle can lead to networking isolation, where a man loses access to the very professional referrals and high-level social introductions that fueled his rise in the first place. Do you know how to identify which friends will disappear the moment the papers are filed? We are going to break down the strategic reconstruction of your social net worth, and why your new inner circle will be the ultimate predictor of whether you climb back up the ladder or slide further down. This is where the psychological and the economic collide. Social capital is the invisible currency of the American elite, and for the high-achieving man in 2026, it is often the primary driver of upward mobility. We have spent the last 4 parts of this masterclass dissecting the tangible assets like 401ks, real estate, and tax brackets, but now we must address the social bankruptcy that frequently follows a legal separation. In the United States, professional advancement is rarely a meritocracy of skill alone. It is a meritocracy of proximity. When you lose access to the social circles you spent a decade cultivating as a couple, you aren't just losing friends. You are losing your funnel for information, referrals, and high-level opportunities. This is the social capital collapse, and for many men, it is the final push into permanent downward mobility. To visualize this, let us look at a case study involving Christopher, a 48-year-old senior executive in the Seattle tech corridor. In early 2026, Christopher's life looks like the blueprint for American success. He is a member of an exclusive golf club, he serves on the board of a local nonprofit, and his weekends are filled with social gatherings involving other directors, venture capitalists, and industry leaders. However, 80% of these connections are what sociologists call joint social capital. These relationships were forged through the couple's circuit, dinner parties, shared vacation rentals in Suncadia, and school auctions. The moment Christopher's divorce becomes public knowledge, he experiences a phenomenon known as social pruning. In the 2026 social landscape, people are increasingly risk-averse. When a high-status couple splits, the surrounding network often views the situation as a social contagion. To avoid the awkwardness of choosing sides or being caught in the middle of a legal dispute, the network simply stops inviting the individual. Christopher finds himself excluded from the very Saturday night dinners where the real business of Seattle happens. He loses the informal mentorship he was receiving from a retired CEO. He is no longer the first person called when a new board seat opens up. Within 12 months, Christopher's professional network has shrunk by 60%. Historically, this isolation leads to a plateau in earning potential. Without the constant influx of new social data and high-level introductions, Christopher becomes a localized asset, stuck in his current role while his mobile, socially connected peers leapfrog him into the C-suite. This leads us to the concept of networking isolation. In the United States, the most lucrative job opportunities are never posted on public job boards. They are filled through weak ties, the acquaintances of your friends. When a man undergoes a divorce, his weak ties are often the first to sever. Imagine if Christopher's primary source of industry intel was a group of fathers from his children's elite private school. If the divorce proceedings result in a change of school or a move to a different neighborhood, those ties are cut. He is no longer in the loop regarding which companies are preparing for an IPO or which firm is looking for a new regional lead. Step by step, his professional intelligence gathering is degraded. He is forced to rely on formal channels, which in 2026 are crowded and hyper-competitive. This is how a man who was once at the cutting edge of his industry finds himself struggling to stay relevant within 2 years of a final decree. We must also analyze the psychological impact of social isolation on financial decision-making. High-stakes social mobility requires a mindset of abundance and a high tolerance for calculated risk. However, when a man is socially isolated, he often shifts into a scarcity mindset. He becomes defensive. This is the echo chamber risk. Without a diverse group of high-achieving peers to provide perspective, many men surround themselves with other individuals who have experienced bitter divorces. They enter a feedback loop of resentment and financial fear. Historical trends show that men in this state are significantly more likely to make poor investment choices, such as liquidating growth stocks during a market dip or failing to invest in their own professional development. They stop seeing themselves as a rising asset and start seeing themselves as a depreciating one. To combat this, a man must engage in a strategic reconstruction of his social net worth. This is not about joining a dating app. It is about a cold-blooded audit of your professional and personal associations. Step 1 is the identification of independent ties. Who in your life is connected to you solely based on your merit and character, rather than your marital status? These are the foundations of your new network. Step 2 is the diversification of social capital. In 2026, this means moving beyond the neighborhood and school circles. It means joining industry-specific masterminds, alumni associations, and professional organizations where the membership is individual, not familial. Christopher, for example, would be well served to pivot his energy from the country club to a high-level tech founders circle in downtown Seattle, where his value is dictated by his architectural expertise rather than his presence at a suburban brunch. Step 3 is the concept of the board of advisors. Every man concerned with social mobility needs a personal board of directors, 5 individuals who are further ahead on the ladder and can provide objective guidance. This board should include a financial mentor, a legal strategist, a health advocate, and 2 professional peers. During a divorce, this board replaces the emotional support of a spouse with the strategic support of a team. It prevents the social isolation that leads to downward mobility by forcing the man to remain accountable to his long-term goals. There is also the matter of the primary caretaker perception. In many U.S. professional circles, there is an unconscious bias against men who are navigating complex custody arrangements. Colleagues may assume that because you are now a single father with 50-50 custody, you are no longer available for the late-night sessions or the international travel required for top-tier promotions. This is a subtle form of career sabotage. To maintain your trajectory, you must proactively manage this narrative. You have to demonstrate that your productivity remains unlinked to your household structure. This often requires an even higher level of organizational discipline than was necessary during the marriage. If you allow the office to see you as a man in crisis, they will treat your career as a project in maintenance mode rather than a growth asset. As we look at the data for 2026, it is clear that the men who successfully navigate divorce without losing their social standing are those who treat their social life as a portfolio. They don't let it crash. They rebalance it. They understand that their net worth is a lagging indicator of their network. By the time Christopher realizes he has been excluded from the inner circle, his earning power has already begun to decline. The proactive man anticipates this. He builds his lifeboats before the ship starts taking on water. This reconstruction phase is critical because it prepares you for the most high-stakes environment you will face, the deposition and the courtroom. While we have discussed the social and financial structures, we have not yet touched on the psychological warfare that occurs when your personal life is under a microscope. In the next part, we are going to look at the psychology of asset defense. We will break down how the opposition uses emotional triggers to make you look like an unstable professional in front of a judge, and the specific tactics you can use to maintain a stoic, executive presence when everything you have built is being questioned. Do you know how to handle a line of questioning that is designed to make your high-pressure career look like a liability to your children? We are going to dive into the behavioral science of the courtroom and why your ability to remain calm is worth more than any legal argument your attorney can make. The psychology of the courtroom is fundamentally a game of perception management, and for the high-achieving American man in 2026, the stakes are nothing less than his professional identity and his future earning capacity. In the adversarial theater of a U.S. family court, your greatest asset, your ambition, can be systematically reframed as a deficit. We must examine the phenomenon of the ambitious man's paradox. To maintain your social mobility, you must work long hours, travel, and remain hyper-competitive. Yet, in a custody or support hearing, these very traits are often weaponized to suggest that you are an absentee parent or that your lifestyle is inherently unstable. This is where behavioral science becomes a survival tool. Consider the case study of James, a 42-year-old algorithmic trader in Chicago. In early 2026, James is navigating a high-conflict divorce. During a deposition, the opposing counsel begins a line of questioning focused on James's work schedule. They highlight his 4 a.m. starts and his frequent late-night calls with international markets. The strategy is to create a narrative that James is married to his terminal, not his family. If James reacts with defensiveness or worse, arrogance about his high income, he falls into a trap. Historical trends in family law suggest that judges often favor the status quo of caretaking. If James appears agitated or condescending, he reinforces a negative stereotype of the cold, disconnected high earner. This perception can lead to a reduction in parenting time, which in turn increases his child support obligations and reduces his ability to claim certain tax credits, creating a direct hit to his long-term capital accumulation. The key to navigating this is the executive presence protocol. In the 2026 legal landscape, you must view every interaction, every email, every text message, and every minute in a deposition as a piece of evidence that will be reviewed by a forensic psychologist or a judge. Imagine if you are being baited into a confrontation via a parenting app. If you respond with a 3-paragraph rant about your financial contributions, you have provided the opposition with Exhibit A of an aggressive personality. However, if you respond with a 3-word professional confirmation, you have demonstrated the stoic, regulated temperament of a leader. In a courtroom, the man who loses his cool loses his leverage. Your ability to remain calm under the pressure of personal attacks is the primary indicator of your fitness for the high-stakes responsibilities of both fatherhood and professional leadership. We also have to look at the intersection of psychology and the best interests of the child standard. In the United States, this standard is subjective and heavily influenced by the psychological evaluations of the parents. If a man is struggling with the emotional toll of his social mobility collapsing, he may exhibit signs of situational depression or high anxiety. In a 2026 divorce, these are not just health issues. They are legal vulnerabilities. Opposing counsel may argue that your mental state makes you a risk or a less-than-ideal primary custodian. To defend your assets and your role in your children's lives, you must be proactive in your psychological defense. This doesn't mean hiding your struggles. It means documenting your commitment to wellness. Men who engage in professional coaching or therapy during a divorce are historically seen as more stable and self-aware by the court, which can neutralize attempts to use their emotional state against them. Furthermore, we must address the lifestyle analysis, often performed by forensic accountants. In 2026, these experts don't just look at your bank statements. They look at your digital footprint. They look at your LinkedIn activity, your travel history, and even your grocery delivery habits to build a profile of your standard of living. If you have spent the last 5 years living an upper-middle-class life, the court will aim to maintain that standard for your spouse and children, regardless of how much your personal net worth has been liquidated by the divorce itself. This creates the alimony cliff. You are expected to fund a lifestyle that was built on 2 incomes or a much higher level of liquidity than you currently possess. To fight this, you need a psychological shift from providing to surviving. You must present a realistic, data-driven picture of your post-divorce financial reality, stripped of the ego-driven need to appear wealthier than you are. Step by step, the psychological defense of your assets requires a deposition drill. You must work with your legal team to anticipate the most inflammatory questions. Imagine if they ask about your past expenditures on hobbies or luxury items. If you answer from a place of guilt, you concede that those funds were wasted marital assets. If you answer from a place of professional necessity, viewing a club membership as a networking tool or a high-end vehicle as a requirement for client relations, you are framing your spending as an investment in the marital estate's earning power. This reframing is essential for social mobility. You are not a man spending money on yourself. You are a professional maintaining the infrastructure of your income. There is also the conflict cost to consider. In the 2026 U.S. economy, high-conflict divorces act as a massive tax on your mental bandwidth. Every hour you spend arguing over a piece of furniture or a holiday schedule is an hour you are not spent generating revenue or strategizing for your next career move. Historical data shows that men who choose strategic concession, giving up minor tangible assets to secure major intangible ones like final decision-making authority or a favorable relocation clause, recover their pre-divorce net worth 40% faster than those who fight for every penny. You have to treat your peace of mind as a finite resource. If you allow the divorce to occupy 80% of your mental space, your social mobility will stall because you have no innovative surplus left to apply to your career. We must also talk about the guardian ad litem or GAL. In many U.S. states, this is an attorney or social worker appointed to represent the children's interests. For the ambitious man, the GL is a critical gatekeeper. They will visit your home and observe your interactions. If your home looks like a temporary bachelor pad, devoid of the markers of a stable, upwardly mobile environment, the GL may report that your environment is not conducive to the children's well-being. This is where strategic domesticity comes in. You must curate your living space to reflect the social standing you intend to keep. This isn't about luxury, it's about stability. A well-organized, functional home suggests a man who is in control of his life, which translates to a more favorable report and, ultimately, more time with your children. As we conclude this deep dive into the psychology of the courtroom, it is clear that the legal battle is won or lost in the mind long before it reaches a judge. You are being tested for your resilience. If you can maintain the same level of professional excellence and emotional regulation that got you to the top of the ladder in the first place, the court's attempt to deconstruct your life will fail. But even if you win the psychological war, there is one final massive hurdle that most men never see coming until it is too late. In the next part, we are going to look at the insurance and benefits black hole. We will analyze how the loss of a spouse's health insurance or the requirement to maintain a multi-million-dollar life insurance policy to secure your support obligations can create a massive, hidden monthly expense that bleeds your cash flow dry. Do you know how a change in your beneficiary status can accidentally trigger a breach of your divorce decree? We are going to look at the fine print of your benefits package and how to keep the safety net from becoming a financial noose. This is where the protection of your future self begins. The transition from a dual-income, multi-benefit household to a single-entity financial structure is often where the most insidious leaks in a man's wealth occur. In the United States, we frequently focus on the big-ticket items like the house or the 401k, but the insurance and benefits black hole can consume up to 15% of a man's post-divorce take-home pay if not managed with surgical precision. By 2026, the cost of private health insurance and the complexity of court-mandated life insurance riders have reached historical highs, creating a structural barrier to social mobility that can last for 2 decades. Imagine a case study involving a project lead named Steven, based in Phoenix, Arizona. Steven is 46 and earns $185,000 a year. During his marriage, his family was covered under his spouse's premium corporate health plan. Upon the finalization of the divorce in 2026, Steven is removed from that plan. He now faces the COBRA trap. While COBRA allows for the continuation of coverage, the premiums are often staggering because the employer no longer subsidizes the cost. For Steven, staying on that plan could cost him $2,200 a month. If he switches to his own employer's plan, he might find the deductible is $5,000 higher, and his out-of-pocket maximum has doubled. This is a direct hit to his liquid cash flow. For a man trying to maintain an upwardly mobile trajectory, an unexpected medical bill or a high monthly premium is capital that isn't going into his brokerage account. It is the definition of a financial friction point. Furthermore, we must address the life insurance security requirement. In many U.S. jurisdictions, the court will order the person paying alimony or child support to maintain a life insurance policy sufficient to cover the total value of those future payments. This is known as securing the support obligation. For a man in his late 40s or 50s, the premiums for a $1 million term life policy can be significant, especially if he has any underlying health conditions. In 2026, the insurance industry has integrated more aggressive actuarial models, and the cost of these mandated policies has risen. If Steven is ordered to maintain a $2 million policy to secure 15 years of child support and 7 years of alimony, he is looking at a permanent, non-negotiable monthly expense that provides him zero personal utility. It is an insurance policy for his estate, but it acts as a tax on his current lifestyle. There is also the beneficiary designation minefield. Historical trends show that many men fail to update their beneficiary forms on their employer-provided life insurance, AD&D insurance, and 401k plans after the divorce decree is signed. However, in 2026, federal law under ERISA often overrides state laws regarding automatic revocation of ex-spouses as beneficiaries. If Steven were to pass away without updating these forms, his ex-spouse might legally receive the payout despite what the divorce decree says. Conversely, if he updates them in violation of a court order requiring him to maintain the spouse as a beneficiary to secure support, he could be in contempt of court. This creates a legal and financial paradox. You must balance the federal requirements of your benefits coordinator with the specific mandates of your state-level divorce decree. Failure to align these two can lead to litigation that drains your remaining assets. Let us look at a step-by-step breakdown of the Health Savings Account, or HSA. In the United States, the HSA is one of the most powerful tools for social mobility because of its triple tax advantage: tax-deductible contributions, tax-free growth, and tax-free withdrawals for medical expenses. During a divorce, the HSA is a marital asset. If Stephen's spouse receives half of the HSA balance, Stephen loses not just the cash, but the compounded growth of that tax-sheltered vehicle. In 2026, with the rising cost of healthcare and retirement, losing $20,000 in an HSA at age 45 is equivalent to losing nearly $80,000 in future purchasing power by age 65. To mitigate this, a man should strive to offset the HSA value with other, less tax-efficient assets. Taking the full HSA while giving up an equivalent amount in a standard savings account is a strategic move for long-term wealth preservation. We also need to consider the disability insurance gap. For a high earner, your greatest asset is not your house or your 401k. It is your ability to earn an income. Most employer-sponsored disability plans only cover 60% of your base salary, and often have a cap that is far below the needs of a man paying for 2 households and court-ordered support. If Stephen becomes disabled in 2026, his income drops by 40%, but his alimony and child support obligations do not automatically disappear. He would have to file a motion for modification, which takes time and legal fees. Without a supplemental, private disability insurance policy that is portable and covers his specific support obligations, Stephen is one illness away from total financial collapse. This is why the social mobility of many men is so fragile. They are overinsured for their death but underinsured for their survival. The 2026 landscape of Social Security benefits also plays a role in long-term mobility. In the United States, if a marriage lasts at least 10 years, a divorced spouse is entitled to claim benefits based on the other spouse's earnings record. While this does not reduce the amount the man himself receives, it is a factor in overall estate planning. However, many men are unaware that if they remarry, it can change the math on their own survivor benefits and how their estate is taxed. This is part of the hidden balance sheet of divorce. You are not just splitting the assets you have today. You are splitting the entitlements you have earned through decades of labor. To navigate this black hole, you must perform a benefits audit. Step 1 is a review of your summary plan description from your HR department. You need to know exactly how your benefits change upon a qualifying life event, like divorce. Step 2 is the insurance neutralization strategy, finding the most cost-effective way to meet court mandates, such as using a declining term life policy that reduces in coverage as your total support obligation decreases over time. Step 3 is the successor beneficiary update, ensuring that your parents, siblings, or a trust for your children are correctly positioned to receive assets in a way that aligns with your new social mobility goals. As we move toward the final stages of this masterclass, it is evident that the man who succeeds is the one who manages his life like a high-end corporation. You have optimized your taxes, your social circle, and your insurance. But there is one area that is the most volatile and has the highest potential for both destruction and redemption: the multi-generational wealth transfer. In the next part, we are going to look at the inheritance and trust shield. We will analyze how to protect your future inheritance from becoming a marital asset and how to structure your own estate so that your children's social mobility is protected from future legal disputes. Do you know how a commingled inheritance can be legally seized years after you received it? We are going to look at the laws of 2026 regarding separate property and why your parents' estate plan is now a critical part of your own divorce strategy. The concept of inheritance is often viewed as a future windfall, but in the high-stakes environment of a 2026 divorce, it is a primary target for asset reallocation. In the United States, the legal theory generally holds that inheritances are separate property, provided they are never commingled with marital assets. However, the gap between legal theory and the reality of a courtroom is where many men lose their family legacy. To protect your social mobility, you must understand that an inheritance isn't just money. It is a multi-generational battery that powers your family's status. If that battery is drained or shared during a dissolution, the trajectory of your children and grandchildren is altered. Imagine a case study involving a project manager named Thomas, based in Columbus, Ohio. In 2026, Thomas's father passes away, leaving him a $300,000 inheritance. Thomas, believing the law inherently protects this gift, deposits the check into the joint high-yield savings account he shares with his spouse. They use $50,000 to renovate their kitchen and keep the rest in the account for a rainy day. 6 months later, Thomas enters divorce proceedings. Because he deposited the funds into a joint account and used a portion for a marital purpose, the home renovation, the court may rule that Thomas intended to transmute the separate property into a marital asset. The $250,000 remaining is no longer Thomas's separate legacy. It is now part of the marital pot to be split 50-50. This is the commingling trap. Historical trends suggest that once separate funds touch a joint account, the burden of proof to trace them back to their original source is so high and the forensic accounting fees so expensive that many men simply concede the loss. To prevent this, we must look at the step-by-step segregation protocol. If you receive an inheritance in 2026, the first and most critical step is to open a completely new individual account in your name only. The funds must go directly from the estate to this solo account. Every dollar that leaves that account must be documented. If you use it to buy a car, the title must be in your name only. If you use it for a down payment on a property, that property's equity must be protected by a postnuptial agreement or a specific legal carve-out. In the 2026 economic climate, where property values are a key indicator of social mobility, protecting the source of funds is the only way to ensure your family's historical wealth isn't liquidated to pay for a legal battle. We also have to analyze the inheritance and support calculation. Even if an inheritance is successfully kept as separate property and not split in the divorce, it still impacts your social mobility through the lens of income. In many U.S. states, the interest or dividends generated by a separate inheritance are considered income available for support. Imagine if Thomas's $300,000 is invested and generates $15,000 a year in dividends. The court may add that $15,000 to Thomas's annual salary when calculating alimony and child support. While the principal is safe, the cash flow it generates is diverted. This means Thomas cannot reinvest that money to grow his wealth. He is forced to use his family's legacy to subsidize his post-divorce obligations. This is why the shielding of yield is a major topic in 2026 family law. Then there is the issue of the expected inheritance. In high-conflict cases, opposing counsel may look at the wealth of your parents as a factor in your future financial circumstances. While a judge cannot usually award a spouse money that your parents haven't even given you yet, they can use the knowledge of a massive future inheritance to justify giving the spouse a larger share of the current marital assets. The logic is that you will be fine later, so the spouse needs more protection now. This is a subtle but devastating blow to your current net worth. It effectively forces you to borrow against your parents' death to pay for your divorce today. To counter this, your parents' estate plan should ideally utilize a discretionary spendthrift trust. In 2026, these trusts are the gold standard for protecting multi-generational social mobility. If the money is held in a trust where you do not have a guaranteed right to the principal or income, it is much harder for a court to count it as a financial resource. Let us look at a scenario involving the transmutation of real estate. Imagine if Thomas inherits his childhood home. He and his spouse move in, but they use marital income to pay the property taxes and the new roof. Under the laws of 2026, the spouse may now have a community interest or equitable interest in the appreciation of that home. If the house was worth $500,000 when he inherited it and is worth $700,000 at the time of divorce, the spouse may be entitled to half of that $200,000 increase. Thomas has successfully kept the original $500,000, but he has lost $100,000 of his family's appreciating asset. This is why a living trust with specific separate property designations is not just for the ultra-wealthy. It is a fundamental tool for any man who wants to maintain his family's position on the social ladder. Furthermore, we must address the gifting trap. In the United States, many parents provide early inheritances in the form of large gifts for a down payment or a business venture. In 2026, if these gifts aren't structured as formal, interest-bearing loans with a promissory note, they are almost always treated as unconditional gifts to the marriage. If Thomas's parents gave the couple $100,000 to start a business, and that business is now being valued for the divorce, the spouse is effectively getting $50,000 of the parents' money. Historical cases show that without a paper trail defining the gift as a loan or a specific gift to one individual, the intent is irrelevant in the eyes of the law. You must treat your family's generosity with the same legal rigor as a bank transaction if you want to preserve that capital for your future. The 2026 landscape also sees the rise of digital inheritance and intellectual property. If you inherit a stake in a family business or a patent, the valuation becomes incredibly complex. Opposing attorneys will hire intangible asset appraisers to put a price tag on the future earnings of that inheritance. This can lead to a situation where you are forced to pay your spouse a buyout for a family business you haven't even taken over yet. This creates a massive debt load that can cripple your ability to actually run the business when the time comes. This is the succession tax of divorce. To protect your legacy, Step 1 is a generational strategy session. You must talk to your parents about their estate plan and ensure they are using bloodline trusts that keep assets within the family tree. Step 2 is asset siloing, keeping your inherited wealth in a completely different financial institution than your marital accounts to avoid even the appearance of commingling. Step 3 is the forensic audit trail. Keep every bank statement, every estate closing document, and every letter of intent from the day you receive the funds. In a 2026 courtroom, the man with the best documentation is the man who keeps his inheritance. As we move toward the final parts of this masterclass, we have covered the defense of your past and your present. But social mobility is ultimately about the future, specifically the cost of launching the next generation. In the next part, we are going to look at the college education extortion. We will analyze how Section 529 plans are handled in a divorce and why your obligation to pay for university might be legally extended far beyond what you expected, potentially draining your retirement funds just as you reach your peak earning years. Do you know how a choice of school clause can cost you an extra $200,000 in tuition? We are going to break down the educational math that determines whether your children reach the next rung of the ladder or start their lives in a mountain of debt. In the American socioeconomic landscape of 2026, higher education remains the primary gatekeeper for social mobility, but in a divorce, it becomes a high-stakes financial battleground that can jeopardize your retirement and your children's independence. For the upwardly mobile man, the 529 college savings plan is often one of the most substantial assets on the balance sheet. However, many men are shocked to discover that these accounts, while intended for the children, are legally considered marital property in many jurisdictions because the parents are the account owners. This leads to the 529 liquidation trap. Imagine a case study involving a healthcare administrator named Kevin in Indianapolis. Over 12 years, Kevin and his spouse meticulously contributed to a 529 plan for their 2 teenagers, reaching a balance of $180,000 by early 2026. During the property division phase, Kevin's spouse argues that the 529 balance should be counted as part of Kevin's share of the marital assets if he wants to remain the account custodian. If the court agrees, Kevin effectively pays $90,000 out of his other retirement or liquid assets just to keep the college fund intact for his kids. If he refuses, the court may order the account to be split, or worse, liquidated. Liquidation in 2026 is a catastrophe. It triggers a 10% federal penalty on the earnings and subjects those earnings to ordinary income tax rates. This can wipe out 20 to 30% of the fund's value instantly. For Kevin, this is a massive blow to his family's social mobility. He is either losing his own wealth to save the college fund or watching the college fund burn, forcing his children to take on high-interest student loans. Beyond the existing savings, we must address the post-majority support for education. While many assume child support ends at age 18, several U.S. states, including Massachusetts, New Jersey, and Illinois, allow courts to order parents to contribute to college expenses well into a child's early 20s. This is often referred to as a Section 501.1 or a college contribution order. Historical trends show that these orders can be incredibly broad, covering tuition, room, board, books, and even health insurance. If Kevin is ordered to pay 60% of a private university tuition in 2026, where costs at elite institutions are now exceeding $85,000 a year, he is looking at a $51,000 annual post-tax expense. This is money that cannot be deducted from his taxes and is paid after he has already fulfilled years of standard child support. For a man in his 50s, this expense occurs exactly when he should be aggressively maxing out his catch-up contributions for retirement. This is the educational pincer movement. Your income is capped by your divorce decree, your expenses are spiked by tuition, and your window for wealth accumulation is closing. The choice of school clause is another high-stakes variable. Imagine if Kevin's divorce decree states that both parents must agree on a college, but if they disagree, the court will decide based on the child's best interest. In 2026, if a child is accepted to an out-of-state Ivy League school and a local state university, The court may lean toward the prestigious institution to maximize the child's social mobility. This decision could be the difference between a $40,000 total obligation and a $250,000 one. Historical cases indicate that men who do not include a tuition cap in their final decree, often pegged to the cost of the state's flagship university, are vulnerable to unlimited educational liability. Without this cap, your financial planning for the next decade is impossible. You are essentially signing a blank check for an unknown future expense. We must also analyze the impact on financial aid eligibility. In the 2026 FAFSA environment, the rules for which parents' income is reported have shifted. Previously, it was the custodial parent. Now it is often the parent who provides the most financial support. If Kevin is the higher earner and provides more than 50% of the support, his income alone will likely disqualify the child from any need-based grants or subsidized loans, even if his net worth has been decimated by the divorce. The system sees Kevin's gross income, not his post-alimony, post-legal fee reality. This places the entire burden of social mobility on Kevin's shoulders, while his children are locked out of the very subsidies that were designed for the middle class. To mitigate this, a man must engage in strategic timing of asset transfers and support payments to ensure that the child's aid eligibility is not unintentionally destroyed by the way the divorce decree is drafted. There is also the matter of the graduate school extension. In certain high-conflict cases, especially among the professional elite, there is a push to extend support for professional degrees. If a child decides to pursue a JD or an MD in 2026, a spouse may argue that the family's high social standing dictates that the father should contribute to this advanced education. While less common than undergraduate orders, the mere litigation of this issue can cost tens of thousands in legal fees. It is a form of status maintenance that the legal system can enforce at the father's expense. You are effectively paying for your child to enter the upper class while you are being pushed down into the middle class to fund it. Step by step, a man must protect his educational solvency. Step 1 is the 529 protection rider. You must negotiate for the 529 plans to be classified as non-marital assets held in trust for the children, removing them from the equitable distribution math. Step 2 is the tuition ceiling. You must insist on language that limits your contribution to a specific dollar amount or a percentage of the average in-state tuition at a public university. Step 3 is the condition of enrollment clause. This requires the child to maintain a certain GPA and a full-time credit load to trigger your payment obligation. This ensures that your investment in their social mobility is being met with a reciprocal level of effort and accountability. Furthermore, we must look at the hidden cost of the transition years. The period between age 18 and 22 is when many young adults are most vulnerable to the fallout of a parent's divorce. If the father's ability to provide a launchpad, such as a car, an internship network, or a down payment on a first apartment, is stripped away by the divorce, the child's upward mobility is delayed. Historical data suggests that children from high-conflict divorces often take 3 to 5 years longer to reach financial independence. This means the father remains a financial safety net for longer, further delaying his own wealth recovery. This is the failure to launch cost that is never calculated in a courtroom, but is a reality for the 2026 American male. As we reach the penultimate part of this masterclass, we have deconstructed every structural force that threatens to pull you down the social ladder. You have the tools for tax defense, career preservation, and educational protection. But all of this knowledge is useless without the final piece of the puzzle, the rebuilding phase. In the next and final part, we are going to look at the wealth velocity reset. We will break down how to reconstruct a multi-million-dollar net worth from a 50% starting point using the 2026 economic tailwinds. Do you know the rule of 7 for post-divorce recovery? We are going to look at the specific investment vehicles and psychological shifts that allow a man to not just return to his previous status, but to surpass it and secure a legacy that is truly divorce-proof. This is the blueprint for your second act. The blueprint for your second act begins with a fundamental acceptance of the math. You are likely starting over with 50% of your previous assets, but you still possess 100% of your earning capacity and human capital. In the 2026 economic landscape, wealth velocity is determined by how quickly you can pivot from defensive litigation to aggressive accumulation. To achieve this, you must apply the wealth velocity reset. This is a strategic framework used by high-net-worth individuals who have successfully navigated the downward pressure of divorce to reclaim their spot in the top quintile of American earners. Imagine a case study involving an executive named Anthony in Seattle. In late 2026, Anthony has just finalized a 2-year divorce process. His net worth has dropped from $4 million to $1.8 million after legal fees, asset division, and the buyout of the family home. At 50 years old, Anthony feels the weight of lost time. However, the wealth velocity reset dictates that Anthony shouldn't just look at the raw number. He must look at his burn rate. While married, his household expenses were $25,000 a month. Now, as a single man with a streamlined lifestyle, his essential expenses have dropped to $9,000. This delta, the $16,000 a month in freed-up cash flow, is his most powerful weapon. Historically, men who treat this newfound cash flow as a seed fund for high-yield opportunities recover their original net worth within 7 to 9 years. Step 1 of the reset is the rule of 7. In the United States, historical trends in the equity markets suggest that capital doubles approximately every 7 to 10 years, depending on the rate of return. For Anthony, his $1.8 million is not a defeat. It is a seed that, if left undisturbed and managed with tax efficiency, can potentially reach $3.6 million by the time he is 57. The goal in 2026 is to minimize friction. This means utilizing tax loss harvesting to offset the capital gains he might have incurred during the asset division, and ensuring that his portfolio is rebalanced to reflect a more aggressive growth stance, now that his household liability has been halved. Step by step, the rebuilding process requires a shift into high-leverage assets. In 2026, this often involves the strategic use of solo 401ks or SEP IRAs for those with consulting income. If Anthony takes on a side advisory role, common for high-level executives, he can shield a significant portion of that income from taxes, accelerating his recovery. We must also look at the psychological shift from consumer to investor. During the marriage, much of Anthony's wealth was likely tied up in lifestyle assets: the primary residence, luxury vehicles, and club memberships. These are depreciating or stagnant assets in terms of social mobility. In his second act, Anthony pivots to cash-flowing assets: real estate syndications, private equity, or dividend growth stocks. By shifting the composition of his net worth from debt equity in a house to active equity in the market, he increases his wealth velocity. We must also address the professional pivot. In the United States, the most significant salary jumps often happen when an individual switches companies or industries. After a divorce, many men feel a sense of loyalty to their current employer because they provided stability during the crisis. However, social mobility in 2026 favors the mobile. If Anthony uses his new independence to take a high-risk, high-reward role at a startup or an international firm, he can potentially increase his base compensation by 30%. This independence premium is a direct benefit of the divorce that is rarely discussed. Without the need to coordinate a move with a spouse or maintain a specific suburban social standing, Anthony is now a liquid asset in the labor market. Consider the scenario of the divorce-proof legacy. To ensure that this social mobility is never threatened again, the 2026 man utilizes the legal structures we've discussed, specifically the Domestic Asset Protection Trust. By placing his newly rebuilt wealth into a structure that is legally separate from his personal balance sheet, Anthony ensures that any future relationship or legal dispute cannot reach the core of his estate. This is how the wealthy maintain their status across generations despite personal upheavals. They don't own the assets, they control them through entities. This distinction is the hallmark of the upper class in the United States. Then there is the concept of the social mobility compounder, mentorship, and masterminds. As we discussed in the social capital segment, your recovery is accelerated by the caliber of the people you surround yourself with. In 2026, Anthony joins an elite mastermind for divorce professionals. Here, he isn't just finding emotional support, he is finding co-investors. He is finding a new tax attorney who specializes in high net worth recovery. He is finding a peer group that views his divorce not as a tragedy, but as a strategic restructuring. This environment creates a psychological floor that prevents him from slipping back into a scarcity mindset. Furthermore, we must look at the long-term impact of the educational launchpad. While we discuss the costs of college, the second act allows Anthony to model financial resilience for his children. By rebuilding his wealth transparently, he teaches the next generation the skills of asset management, risk assessment, and legal literacy. This is a form of intangible wealth that often surpasses the value of an inheritance. Historical data suggests that children who witness a parent successfully navigate a major life setback and rebuild their status develop a higher level of grit and economic adaptability themselves. As we conclude this deep dive masterclass, we must acknowledge the sheer scale of the challenge. The U.S. legal system, the tax code, and the social structures of 2026 are not inherently designed to facilitate your recovery. They are designed for equilibrium, which often means pulling high performers back toward the mean. To resist this, you must be more than just a hard worker. You must be a technician of your own life. You have analyzed the tax traps, you have mapped the career hurdles, and you have fortified your social and psychological defenses. The potential outcomes for the man who follows this blueprint are not just about returning to where he was. They are about reaching a level of financial and personal autonomy that was previously impossible. You are no longer building a life based on a compromise made in your 20s. You are building a life based on the wisdom and the capital you have acquired by your 40s or 50s. This is the ultimate form of social mobility, the ability to reinvent your economic identity from a position of strength. While this part concludes our 10-part masterclass on divorce and social mobility, the journey of your second act is just beginning. Every day in the 2026 economy presents new data points and new opportunities to accelerate your wealth velocity. The question is no longer how much you lost, but how fast you can grow what remains. You have the map, the tools, and the framework. Now it is time to execute. Stay focused on the deltas, protect your liquidity, and never let the friction of the past slow the momentum of your future. Your legacy isn't defined by the dissolution of your marriage. It is defined by the height of your recovery. Keep climbing.